will be observed at all IEC voting stations on the 1st of November. Remember to mask up, put an X for your community. Every voice together.
Catch another installment of Service Delivery Gauge as we focus on Umsunduzi municipality in KwaZulu-Natal.
In Copesville, we've got no help at all.
Every house you go to Copesville, there is a complaint.
We should be the part that will do and make a better change in our community.
Our rates as well cook.
Join Sakina Kamwendo live at 2000 this Sunday on SABC2 and SABC News Channel.
Well, The Week Ahead is a show that airs between 1 and 2 o'clock on SABC News Channel. The show's been extended to an hour. We're going to continue to bring you rolling coverage of what is unfolding every step of the way from our different provinces, different communities, different metros, different areas, parties and independent candidates in full swing campaigning and electioneering ahead of the local government elections. Thank you for joining us. Catch The Week Ahead with myself, Liesl Wilson, on SABC News Channel between 1 and 2 o'clock on Sundays.
Mzansi. Play your part and help curb the spread of COVID-19 by wearing a face mask at all times in public spaces. Practice good hygiene by coughing or sneezing into your elbow, washing your hands with soap and water, and sanitizing regularly. Register to get vaccinated. Together, we can beat COVID-19. The SABC, keeping you safe and informed.
The controversial court judgment on the issue of sexual consent could undermine South Africa's quest to assert the human rights of women, according to legal experts. So this comes after acting Eastern Cape High Court Judge Tembeka Ngcukaitobi overturned the conviction of a former paramedic who was found guilty of raping his girlfriend because, by agreeing to oral sex, Ngcukaitobi ruled she had tacitly agreed to penetrative sex. She was a virgin. Joining me in our live to discuss, Lisa Vetten, who's research project consultant in the Gender, Violence and Urban Transformations Project to the Faculty of Humanities at the University of Johannesburg, and advocate Modidima Mannya, who is a legal analyst and public commentator. To you both, ladies and gentlemen, thank you very much for joining us. Ms. Vetten, perhaps I could start with you. Let me get your comments on this judgment and whether this judgment creates confusion on the interpretation and meaning of consent.
It's a deeply conservative judgment that's extremely disappointing and takes a very, very orthodox and conservative view of the law that has the effect of, unfortunately, shoring up and reinforcing masculinist domination when it comes to sex. It doesn't in any way advance the recognition of women's rights to sexual autonomy. It may be a correct legal judgment in terms of the fact that if you look at the judgment, there is the way in which the judge relied on the element of intentionality in the legal definition, that it's important that you understand what the accused person's intention was. And in this instance, it was the accused is not didn't intend to rape her, he intended to have sex with her. So that on that basis, the judgment could be legally correct, but it's deeply conservative, and I don't think it looks. And all it really does is uphold the idea that men don't really have to make very much effort when it comes to finding out whether or not women have given consent. Not only that, this particular woman twice said to him, "I don't want to have penetrative sex with you." But he persisted in pushing the boundaries, then accused her of giving mixed signals when he was the one who ignored what she had said and left her feeling very confused. So I don't think it's a good judgment in any way in relation to advancing women's rights, but it may be correct on a very conservative legal interpretation.
Advocate, is this a correct judgment I know that you've also penned an opinion basically saying that this does take away the voice of women, because surely at any given moment, a woman, when she feels uncomfortable, does have the right to say stop or no?
Yes, certainly, and that must happen at any stage. But I think let's probably start with the politics of this problem, is that over a period of time, men would determine when and how to have sexual relations and sexual intercourse. the very purpose of the Sexual Offences Act is to partly give effect to the provisions of the Constitution, which will give effect to the rights of women, like the rights of any other person, the right to privacy, the right to human dignity, because rape or, this type of conduct is a gross violation of human rights. Where I am extremely concerned, and I agree with my colleague, is that I think it's a very conservative way of looking at the power relations between the two people. And I think what is not in dispute is that the woman made it very clear that she doesn't want penetrative sex. So it's irrelevant whether she agreed to have oral sex or any other form of sex, but she made it clear that she doesn't want to have penetrative sex. I think the policy question that we should put, to avoid the legalities is, at what point do women choose how they want to participate in sex? Because it seems that the judgment implies that one thing led to the other. I'm not sure whether legally the judgment is correct, because there is a judgment which suggests that explicit opposition is not necessarily, doesn't have to be established. So it's not as if you have to push somebody back. Saying no is enough. But I also think what is probably we need to interrogate is what is the meaning of the agreement between the parties, and who of the parties has the responsibility to comply with the agreement that was reached, because it seems like there was an agreement reached. But beyond that, there were things that I think are very unfortunate in the judgment, about whether the woman was wearing a panty. I don't know what is the relevance of that. Why should women be told what to dress? I mean, we have this situation coming from colonialism, where part of colonialism sought to do was to even tell women how to dress. If she was not wearing panties, nothing turns on it. The question is whether she was required to push somebody away. And I think my colleague has put it probably ably, that there is an environment where vulnerability is created. And those who commit or who go against what was agreed upon should not benefit from their conduct. And I think if there was an agreement that we will not have penetrative sex, I don't think the accused ought to benefit from the fact that he was not pushed away physically.
Ms. Vetten, as someone who deals, with victims of sexual abuse, you've done so for many, many years. How does this judgment set the tone for similar cases of this nature?
Well, it potentially acts as a disincentive to report and to use the criminal justice system, because there's been a long-standing struggle to encourage women to report and to see the law as credible and to be there to support and to take their side and to uphold their rights. A decision like that says, at the end of the day, no, that's not really the case. We're still going to overrule and look at this particular matter and interpret it from a man's perspective, rather than from your perspective or from both parties' perspective. So it may be a real disincentive to report. I also think what's really important is, if you look at this judgment, the young woman concerned did say that she was confused about what was happening. She wasn't too sure how to respond, and she didn't go and report because she was worried about people pitying her or thinking that she was a victim. So I'm afraid all this decision just reinforces some of that. What is also very concerning, in addition to it being a deterrent, is the ripple effects it has on other kinds of law. So the problem is, especially if you move into a labor environment where you have sexual harassment cases, or you're in a university environment where you're trying to deal with these kinds of cases through disciplinary tribunals, is that the chairs or the presiding officers of those particular disciplinary hearings tend to look at what does the criminal law say and then apply it in those disciplinary hearings. So the ripple effects can be broader than even just a criminal trial. It can run into disciplinary hearings, including within labor tribunals. So it is a deeply concerning decision. I think it's unhelpful because on the one hand, we have a society that's saying to women, you have bodily autonomy, you have bodily integrity. It is your right to enjoy sex, to have sex on your terms, and to say what it is that you wish when you want sex to start and when you want sex to stop. And here we have a judgment that says, actually, no, everything we're telling you is nonsense. Plus, we were also constantly saying to women, speak out, tell others what has happened to you. And then this is what happens when they do speak out. So it's a judgment that is at odds with all that we are trying to do, to try and undo our very widespread, deeply entrenched problem of sexual violence in South Africa.
I would have loved to continue this conversation. I'm hoping we'd get a chance to do that at a later stage. Advocate, I do appreciate your insights as well. Thank you very much indeed. Who's a legal analyst and public commentator, as well as Lisa Vetten, who's a research and project consultant in the Gender Violence and Urban Transformations Project at the University of Johannesburg's Humanities Faculty. To you both, thank you very much for your time as limited as it may have been. Let's move on to other stories now. Gauteng Transport MEC Jacob Mababolo is still locked in meetings with two rival Soweto